Hi guys, good evening. So my name is Neha and I'm going to take your subject of current affairs as well as GK. So this subject for CLAT, it revolves around considering the static GK and attaching the current affairs along with it, the recent judgments, legal affairs, etc. Right? So from the first slide, as you see, why this module matters is that the Constitution is an important part of the CLAT exam, and we are going to consider the basics of Constitution and how the current affairs have been attached to Constitution and the main legal provisions of other various laws as well. Because that is how CLAT exam works. You need to know the basics of law as well as the current affairs which come and get attached to it. So, for example, there is a 2024 CLAT example on same-sex marriage judgment. So, it wasn't just a current event; it also tested your understanding of Article 21, that is right to life, and Article 14, that is right to equality. So, that is the level of integration that CLAT now expects, that you should know the legal provision as well as the current affairs, and in a combination of it, a question will be formed. So now coming forward to the basics of the static law that we are going to deal in this particular presentation. So this is structure of Indian Constitution. So as you can understand that Indian Constitution is the longest written constitution in the world. Originally, it was enacted in 1950 with 395 articles and 8 schedules, but as of now, 2025, there are 448 articles spread across 25 parts and 12 schedules of the Constitution. So, Indian Constitution, as compared to other constitutions of the world, is known for its flexibility, allowing amendments through a special procedure, that is under Article 368. It establishes a federal structure with a unitary bias, a unique blend that balances central and state powers. It contains a detailed framework for fundamental rights, governance, judiciary, and legislative procedures. The Constitution has evolved through over 100 amendments over the period of time to address the changing social, economic, and political needs from the time of getting our independence up till now. Moving forward, the preamble, which is an important part of the Constitution. So, preamble introduces the guiding ideals and values of the Constitution. It begins with saying that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, it enshrines 4 core principles. So, first is justice, that covers the social, economic, and political justice. Then we have liberty of thought, of expression, belief, faith, worship. Then equality of the status and opportunity for all citizens, and fraternity that assures dignity and unity of the nation. So the words socialist and secular, they are a new addition as compared to the original constitution, and they were added in the 42nd Amendment in 1976 to reflect India's commitment to social welfare and religious neutrality. There are some constitution basics other than the basic structure of constitution that we must know as a CLAT student. So the first is that it is the world's longest written constitution. It consists of 448 articles and 12 schedules, as we discussed earlier, making it the most detailed written constitution in the world. It is designed to address the complexity and diversity of India and providing for a federal structure, individual rights, and a system of checks and balances. Secondly, there is a preamble which has guiding values. So the preamble sets out the core ideas: justice, liberty, equality, and fraternity. So these values shape the interpretation and the spirit of the Constitution. Then the next important most part of Constitution is the fundamental rights, which start from Article 12 and go till Article 35. So the first under this, the most important is Article 14, which talks about the provision of equality before law and equal protection of the laws to all citizens. Second is Article 19, which protects freedoms such as speech, assembly, movement, residence, and profession. When we will discuss it in detail, we will also discuss the restrictions which come with these freedoms. Then we come to Article 21. So this talks about ensuring the right to life and personal liberty under the Constitution and has been interpreted expansively by the Supreme Court in its various judgments. Lastly, we have Article 32 as one of the most important articles, which has been described by Dr. B.R. Ambedkar as the heart and soul of the Constitution. So it empowers the citizens to approach the Supreme Court directly for the enforcement of fundamental rights through writs under the Supreme Court. Then we have judicial review as a very important aspect of Indian Constitution. So it gets covered under Article 30, 32 and 226. So the judiciary has the authority to review and strike down any law or executive action that violates fundamental rights, ensuring constitutional supremacy. Judicial review is critical for protecting citizens' rights and upholding the rule of law. As a recent example, in Supreme Court of India's case, in May 2025, the right to digital access was recognized as a part of Article 21, that is, right to life, highlighting how the judiciary expands the scope of constitutional rights to address contemporary challenges. As digital access is a contemporary challenge, it wasn't there when Article 21 was formulated. But now judiciary has expanded it to actually consider it as an important contemporary part of our life. So it also has a aspect of our right. We are also working on the digital space, so we need to have a digital access. That is why it has been recognized as a part of Article 21, that is right to life. So this landmark interpretation demonstrates the living nature of the Constitution, that Constitution is not stagnant. It is moving, it is growing with the time. And dynamic role of judicial review. Moving forward, we will discuss some landmark Supreme Court judgments as a part of constitutional and legal developments. So these are mostly recent developments, recent judicial Supreme Court judgments, so as to understand what is the current situation of judicial review and the Constitution. So the first is a case of Gayatri Balaswamy versus ISG Novasoft Technologies Limited. It's a 2025 case judgment. It is based on the basic ideology of modification of arbitral awards. The bench is a constitutional bench of 5 judges. So the issue in this case was that can courts modify an arbitral award under Section 34 or 37 of the Arbitration and Conciliation Act 1996? Because an arbitral award is binding on both the parties, so can the court have the power to modify such arbitral award? So it was held in this particular case that courts cannot alter or reframe the arbitral awards. They can only set aside on narrowly defined grounds. If there are certain grounds on which the award is not standing particularly, then it can be set aside. So that is the bias, illegality, procedural infirmity. In such circumstances, the awards can be set aside. Otherwise, they cannot be altered by the court. So this affirmed the principle of finality in arbitration, as arbitration has been preferred by various corporates also and various entities nowadays, when they sign contracts, it's a newer form of decision making process. So the judgments are also moving forward in the aspect of arbitration, how arbitral awards should be treated. So in this constitutional context, Article 32 and Article 226 have been considered that judicial review is limited in arbitral matters. So why it matters for CLAT? It is important to understand the judicial deference and boundaries of the court intervention. Next, we have the constitutional challenge to the Waqf Amendment 2025. This is also under the recent developments. This is a second case. It's a pending constitutional case of All India Bar Association versus Union of India. So the issue over here is whether Parliament can restructure the Waqf boards and define Waqf by user through a central law. So the arguments raised in this particular case are that the petitioners have raised there is a violation of Article 25 and 26, which deals with religious freedom. And the respondents have claimed that there is a Parliament's right to reform under Article 28, and the entry 28, that is list 3 of concurrent list. So the key concepts are, what are the Waqf by user, first of all. So these are the contested legal concepts which recognize the customary usage as a proof of religious trust, because these terms are being used since a period of time. So to understand the legal concept, you need to understand the customary usage of that particular term. The challenge over here is that whether Parliament encroaches upon the autonomy of religious institutions. There are constitutional articles which are involved in this particular case for discussion. So first is Article 14, which talks about equality before law, that is the state control versus the minority autonomy. Then we have Article 25, which talks about freedom of religion, and Article 26, which talks about management of religious affairs. So the CLAT angle in this particular amendment, if you can see, is that students have to recognize how legislative reform, it collides with religious rights, especially when public land or policy is involved. So you can get a question based on the same. So you need to understand the basic core that in such circumstances, what might be the decision in case a legislative reform collides with religious rights. Although the decision has not come for this particular case, but whenever it is going to come, so we will stay updated with the same. Then we come to the second part of landmark Supreme Court judgments, which talks about welfare, environment, and expansion of Article 21. So in this, the case we are going to study is Urmila Dixit versus Sunil Sharan Dixit and others. It's also a 2025 case and talks about senior citizens' welfare and Article 21. So the issue in this case is enforcement of senior citizens' right to maintenance under Maintenance and Welfare of Parents and Senior Citizens Act of 2007. So it was held in this particular case that right to live with dignity is a part of Article 21. It has under this particular judgment, the court has directed the states to ensure timely grievance redressal and awareness campaigns about maintenance and welfare of parents and senior citizens. So this is also highlighted that constitutional morality includes the care for the aged. The constitutional basis we can understand is the Article 21, which talks about right to life with dignity. And the DPSPs have also been considered when this judgment has been given, especially Article 41, which talks about right to public assistance in old age, and Article 46, which talks about promotion of welfare of the weaker sections. So these two have been considered when this particular judgment has been provided. Next, we come to another case which is under Environment and Pollution Enforcement, which is MC Mehta versus Union of India and others. It's an industrial emissions case of 2025, and the issue in this case is the state inaction in controlling industrial emissions and protecting health. So, in this particular case, it was reaffirmed that the right to clean and healthy environment is a right under Article 21, that is about right to live with dignity. Then, the precautionary principle and polluter pays principle have also been cited in this particular case, and the court has also directed strict penalties on defaulting industries and monthly compliance monitoring. So the constitutional references for this particular case can be understood. First is right to life, that is under Article 21, that life includes the right to clean environment. Second is Article 48A, that is directive to protect environment, and Article 51AG, that is the fundamental duty to protect natural resources. So for this, a small CLAT tip that can be given is that MC Mehta cases are recurring themes in CLAT GK and legal reasoning passages. So all the MC Mehta related cases should be an important aspect to be covered in your course. Moving forward, we have the last case, that is right to digital access as a part of Article 21. So in this case, there has been a discussion about whether digital access is a constitutional right. The name of the case is Digital Equality Foundation versus Union of India. It's a case of 2025. So it was held in this particular case that digital connectivity is now indispensable for life, liberty, education, and livelihood. So the right to digital access is a part of the right to life under Article 21. And under this particular case, the Supreme Court has directed the state governments to ensure affordable internet access, promote digital literacy in rural areas, build inclusive digital public infrastructure. And this is a very relevant case for CLAT students as it tells the example of how evolving technology shapes constitutional interpretation, reflects dynamic nature of Article 21. So this brings us to the end of the discussion on recent Supreme Court and court judgments and how the articles have been brought into place in the recent court judgments. As in, the constitution is lively, it is growing, and it is changing with the rapid environment. So in case you get a question of a legal passage, you can understand the intent behind it and then you can answer the question better. Now moving forward to one important aspect, we will take a passage sample example of a judicial review of arbitral awards. So this is a question, a kind of a question which you can come up with in CLAT exam, and a passage will come to you and some questions will be attached to it. So we will do one sample for the same. So the passage as it reads, in April 2025, the Supreme Court clarified the scope of courts to modify arbitral awards under the Arbitration and Conciliation Act 1996. The judgment reaffirmed that while arbitration aims for finality, the courts retain limited powers to intervene where legal or constitutional principles are at stake, especially concerning violation of public policy or fundamental rights. By restricting intervention, the court seeks to balance fairness for all parties with the need for quick dispute resolution. So this is the passage that has been provided. Now we come to some questions which are attached to it. So the first question which is there is, which constitutional article underpins the judicial review of arbitral awards? So out of these four options, the correct option would be C and D, that is Article 32 and Article 226. As we have discussed the concept earlier, that judicial review can be done under writs as well, under Article 32 and 226. So that is the correct answer in this question. Then we have, according to the passage, under which circumstance may courts interfere with arbitral awards? So the correct answer would be option A and C. Option A says when the award violates public policy, and C is when the award is contrary to the fundamental rights. Then the courts can interfere with arbitral awards. Then we have the third question, that is, why did the Supreme Court emphasize the principle of finality in arbitration? So the correct answer is B, that is to maintain speedy and efficient dispute resolution. So we understand from the passage also that arbitration's main concept is fast and speedy justice and faster decision making process rather than going for a litigation process. So that has to be the basic understanding when the case for arbitration goes to Supreme Court also. That is why the option B is the correct answer, that is to maintain speedy and efficient dispute resolution. So as you can see from all the questions, the basic understanding of the legal subject is going to provide you a faster answer, even if it is related to a current affairs question or a passage question also. Lastly, one more question. So, what role does Article 21 play in the context of arbitral awards as per the Supreme Court's recent interpretation? So, the correct answer over here is option B, that it allows intervention when awards affect life and personal liberty. So, even when it is in context of Article 21, then also Supreme Court's interpretation for arbitral awards is that intervention from the court's end will be when the awards are affecting life and personal liberty, which is the basic right under Article 21. So this brings us to the end of the particular topic. So here there are CLAT law skills, CLAT skills which have been we have practiced in these particular questions. We have taken up a legal comprehension of a passage and we have linked it to particular questions which follow from the trail, right? So basically a passage will be given to you. The basic understanding from the passage will come by having a basic understanding of the subject and linking it to the current affairs, right? Also, very important is the elimination technique in MCQs. So, out of all these options, which option do you understand is the nearest to your particular answer? That also is a part of our practice. So, as we proceed further, we are going to practice it more and more in our whole course. So, I hope you have understood the concept and the subject in this particular presentation. Thank you.